Welcome everybody. Sorry we started a little bit late. It's my pleasure to welcome you on behalf of the Lehman Center for Brazilian Studies and the Institute of Latin American Studies. Today's event is titled The Law's Cheapest Meat, Decolonizing Legal Responses to Necropolitics. Today we are going to be talking about Brazilian Supreme Court case on police violence, and we have the honor of having two wonderful experts on law, both here in the US and Brazil. And I will turn it over to these guys shortly. We'll just give a brief introduction, but just want to let folks know that you can if you want to pose questions during the event, please use the Q&A function, and we'll take a look at those and have time to answer questions toward the end. It's my pleasure to introduce Professor Kendall Thomas, who's an Ask Professor of Law and the Director of Studio for Law and Culture at Columbia University, and a very active participant of all things Brazil on campus. It's an honor to have Kendall here. And we have Thiago Amparo, who is also a law professor, but at the Fundação Getúlio Vargas, and he's at the law school in the International Relations School at FJV, and he's here in New York as a postdoctoral fellow at NYU this fall. So I want to take advantage of Thiago's presence, even though we're doing this virtually. And have a conversation about police violence with these two experts. So I will shut up now and turn it over to Kendall. And again, just as a reminder, please use the Q&A function to ask questions either throughout the talk or towards the end. Thank you both for being here.
Thank you very much, Gustavo. It's a real pleasure for me to welcome Professor Thiago Amparo, who is in the United States. Even though we are, as Gustavo said, conducting this discussion today virtually. And I think what I'd like to do is simply turn things over to Professor Amparo to talk about the fascinating project that is the subject of today's session, The Law's Cheapest Meat, Decolonizing Legal Responses to Necropolitics. Perhaps you can take 20, 25 minutes, and then I'll make some very brief comments, and we'll open up the discussion to our participants.
Thank you very much, Gustavo. Thank you very much, Professor Kendall, for the welcome, and thank you very much virtually, but it feels like a warm welcome here. I will speak briefly about the paper and the overall project in which the paper fits. And the paper is basically, the working paper is called Law's Cheapest Meat, in reference to a song, a Brazilian song. And I know that my colleague Kendall also, in addition to being a professor, is a musician. A Brazilian song that talks about the black meat, or black, it literally says black meat is the cheapest meat in the market. That's the song. So I used this song to coin the title of this paper. And the idea of this paper is to look at the testimonies of black movements and favela movements before the Supreme Court of Brazil. Just a little bit of background, those movements, they presented before the court. First, they request the court to present a petition as friends of the court, and this petition was rejected, largely because they were not official or NGO organization, established organization, which already shows the hierarchy. But later on, they request a revision of this decision, and the Supreme Court allowed them to present orally before the public hearing that the Supreme Court held last year. So the idea of this paper is to re-look at the testimonies of those movements and to see what they were presenting before the court and what they envision as the rule of law in relation to violence and in relation to necropolitics. This paper is a part of the project that I'm conducting here in US, but also I'm going to finish in Brazil, which is a book on the crisis of democracy. And I will start with explaining what I mean by crisis of democracy, and later on I'll explain briefly how I got to this paper specifically. So, as I mentioned, this paper is largely connected to a larger project on a book project on the crisis of democracy. And what usually we count as crisis democracy is in itself an exercise of power, meaning the power to decide what counts as democratically acceptable and democratically unacceptable. Also, it's exercise of a certain epistemological view in the sense that when we talk about crisis democracy in Brazil, we had to consider what events or series of events are to be considered part of the crisis or not. And as we are witnessing several issues in relation to extreme right populism and in relation to several events, especially after Bolsonaro's presidency, usually crisis democracy in Brazil are considered to be this gradual crisis of democracy, more or less related to the literature, which is very valuable, the literature on how democracies die. And my argument in the larger project, in the book project, is to say that, well, although, of course, this literature on how democracies die are very important and they can show indicators of the erosion of democracy in several countries, including in Brazil, this does not tell the whole story. First of all, because, and I advanced three main arguments in the overall project, and then later on I'll say briefly about the paper itself. So the first main argument in this larger project is that I'm interested in looking at how institutions in a democracy advance authoritarianism, meaning, for instance, policing in the case of lecture today, or in the discussion today. I'm not interested in looking at those instances of authoritarian practice as only as leftover of authoritarian times or dictatorship times, or of a colonial past, also it's also important. But I'm interested in seeing how those institutions in a democracy can be profoundly undemocratic in their functioning. So this perspective changes the way we think about how democracies die, because it depends on how we conceive, for instance, historical violence or violence against Black people specifically, which is the topic of the discussion. If we count this as part of the authoritarian practice, we see that it's so gradual, and it's actually very abrupt, and it's very and historically determined, and it's very profound. So it doesn't fit so well. The history of violence against Black bodies in Brazil does not fit so well in the literature of how democracies slowly die. Also, this perspective changes or try to challenge the division between, on one hand, the culture of democracy, and on the other hand, the institutions, because those things are intertwined. In Brazil, we do have a culture of violence and the practice of violence, but at the same time, the institutions that are supposed to be democratic, such as the Public Attorney's Office, which is responsible for overseeing the police or the police itself, are conducting democratic practice largely. So my first argument is to see how institutions in a democracy advance authoritarian practice in one hand. Secondly, my second argument out of three main argument is to see that we had to develop a theory and a practice of democracy that goes beyond simply gradualism. Why? Especially because first, I propose that we should look at democracy as not only as institutions, although institutions, of course, are very important, but also institutions and practice that reflect a form of democratic life which is horizontal and consensual and non-violent. So this is kind of like the normative aspect of the discussion. And I think that if we look at the democracy from that angle, neither the institutions nor the the daily culture that is practiced by the Brazilian society, if you look at the case of violence, actually lead us to a view that the class democracies should be conceived as gradual. If we ask certain groups, such as Black people, the crisis of democracy is deeper than we thought. And on the third aspect, and the third argument is to say that the institution and the law, the legal institutions, they play a double-edged role here. On one hand, the rule of law maintains, when it comes to violence, kind of aspect of legitimacy by establishing rights which exist in theory, but are rarely respected for certain groups, such as Black people in relation to the police. So in one level, it maintains the level of legitimacy. On the other hand, the law itself gives power and legitimacy to institutions which practice violence. So we have, for instance, the police usually framing their violence as a legal practice, saying that they are they have the arrest warrant, saying that they can do that because they are military police. They say that because they know the truth about those crimes, so they establish that. So the law itself maintains, on one hand, a legitimacy of the rights being established, but at the same time provides the power for those institutions to conduct undemocratic and authoritarian practice. And how can we have both of those things? How can we have the law giving legitimacy by establishing rights, and one that rarely exists for certain groups, and on the other hand, how the law can give power to those institutions and shield those institutions from accountability on the other hand? So that's the main puzzle. And my theory to kind of solve this problem, and it's based on Leila Gonzalez's idea of racism by denial, which means that usually people read Leila Gonzalez in the simplistic way to think that she's just saying that in Brazilian society, people are denying that racism exists. But her theory is more complex. She tries to use psychoanalysis to see that we are doing two things at once. We are conducting and practicing racism, in this case through authoritarian practice of the police. But at the same time, we are denying that we are doing so. And also, by denying, we are established some defense mechanisms or coping mechanisms to either suppress or repress those practices. So either by repressing unconsciously those practices, or suppressing in a voluntary and conscious way, in psychological terms. So my theory is that the law serves as this law defense mechanism, because in one hand, by the legitimacy of the law, which establishes rights for people, which are rarely respected especially for the Black people in Brazil, civil rights, the rights of legal guarantees, judicial guarantees, and so on, in relation to the police. So it's the law serves as defense mechanism because it maintains a sphere of legitimacy while giving power to institutions to undermine such legitimacy. So this is a way of using the idea of racism by denial, by saying that we are having this double-edged sword, the double-edged role of the law in relation to the police, which is on one hand legitimacy, on the other hand the democratic practices. So if we do not conceive the crisis of democracy from this perspective, which is taking into consideration the deep-rooted violence against Black bodies, and the deep-rooted not only the violence itself, not only legal violence, but also legal violence established by legal means, you would actually have a problem and not see the whole picture. So in this, I'll say just more 8 minutes, but this lecture, this working paper is based on, as I mentioned, the speeches by the favela movement before the Supreme Court. And what I try to do is that I try not to see them as merely as victims of the police violence, although they are, of course, but also they are political subjects. They are political agents. And what they are trying to do before the Supreme Court is not only telling their own stories, but also they are trying to tell their stories. And by doing so, they are looking at what's the role of law in relation to violence. So I think they are doing more than just telling sad stories about themselves, but also they actually using those stories as a powerful tool to see to kind of determine the role of law in relation to violence. There is a background a theoretical perspective here, which is usually necropolitics is defined. There are several, of course, several definitions, but one possible definition is that when we look at the exercise of power by death, not only killing people, but also subjecting people to a state of terror and subjecting people to a large-scale violence or imprisonment and other controls of bodies in relation to death or near-death experiences. This practice usually is defined in legal terms as a non-legal space. It's usually defined that, well, law is out there somewhere and not inside of the necropolitics, because the necropolitics is exercise of power of the power over black bodies as such, not a legal exercise. So Silvia Almeida, for instance, mentioned that it's a non-legal space where the law does not reach. I disagree. I believe that my argument is that, well, the law, because the law is this double-edged sword, the law can do both. The law that can, on the one hand, maintain the atmosphere and the skeleton of the legitimacy of the rights being established and kept kept in the law, in the books, but at the same time it can give power to the institutions to undermine such legitimacy. And also, one thing that I see that I try to argue in the paper is that when we look at the narratives of the movements before the Supreme Court, we actually are seeing that they are talking about the ways in which the law actually undermined the very legitimacy of the law itself. So, for instance, and I'll just give a few examples, then I finish. One of the ways in which the law actually provides this tool for undermine its own legitimacy is to impose the heavy burden of a stigma on criminals in black bodies. So, for instance, there is a discussion before the Supreme Court where the father of a 2-year-old son who was killed by the police, he mentions that the most severe pain that he suffers out of his son's killing is by the police is because the police report mentions that he was a criminal, or he was holding a gun or something like this, which is completely absurd because it's a 2-year-old son. And when we look at it, we can look at it only as a tragedy, but also we can look at it as a person who's actually looking at the rights that he or she has before the law and try to understand and interpret those rights in a different way. So the law itself says that no penalty shall pass from the person of the victim, of the convict, meaning that we should not have of course, in this case, there's no condemnation, there's no criminal conviction, of course, as a 2-year-old boy, but at the same time, it means that you should not impose a stigma of criminal that actually attaches to the whole family and to the whole community. And they are looking, and the police has the power to do so while solidifying in public documents this stigma of criminalization by filing reports, and the judiciary later on ratify those the truth established by the police, or even the very practice of policing by ostensibly being in certain areas and being able to do whatever the police wants in certain areas. This is framed also as a legal right. Of course, we can argue that it's not actually a correct interpretation of the law, but my question, in a way, I try to bring a normative perspective on democracy, but in terms of law, I try also to bring a more realistic perspective of the law, meaning that, well, the law is what the legal institutions say the law is. Of course, we can argue against that, but in a way that we should have, of course, a normative perspective of what the law should look like and how moral the law should be. But at the same time, when we look at I'm interested in how in practice, on the street, the law is interpreted and actually framed. So finally, also, you have other legal categories such as self-defense, so legitimate defense, that is used widely by the police to shield itself from any kind of accountability or criticism, or the favela movements claiming a right to be a person, to be a human person, and connect to it the right to life. So they connect the right to life to the fact that they are a person and should not be disposed, and they have a right to be considered a person under the law, or they have a right to property, which is widely destroyed during the police operations, and people connect that with their poor conditions of living, which is also connected to necropolitics in a way of subjecting people to living conditions that are deemed to their destruction. So overall, my argument is that there's argument about the law, and there's a general argument on private democracy. So we have to count as also private democracy those deeply rooted, long-standing inequalities and discrimination, not only as leftover of authoritarian regimes, but also as a reiterated practice of the democratic institutions that existed nowadays. And we had to think about democracy. If we think about democracy, not only also institutions, but also as a form of life, which is should be is somehow horizontal, should be non-violent, and should be consensual. And the institutions and the form of life and the social life should reflect this position, and they are not, and we are very far from doing so. And the law, and the second final point, the law is, as I mentioned, this double-edged sword, in the sense that it provides the legal technology for the sovereign to rule by exception. So in those spaces, things that happen there, and as Deborah Silva mentions, the things that happen there and happen are things that usually that we say doesn't happen anywhere, but they happen there on a daily basis. Those things are, from the legal perspective, they should be the exception, or they are framed as exception. But in those areas, they are constant and ongoing use of the legal technology to continue to maintain this exception. So the law is kind of like the gatekeeper of the lawfulness of the exemption, but because at the same time it provides the rule, the perspective and the space for legitimacy, but at the same time it provides the power of death. And if we do not counterbalance these arguments, we are not going to understand the Christ democracy, and we are not going to understand the role of law in relation to violence. And I think this is very strong and powerful testimonies from the favela movement. Many of them directly directly victim of the violence. But as I mentioned in the beginning, I'm interested in how they frame it, things, and how they frame law specifically. They mentioned very specifically that favela is a place of life, and it should be considered as a place of life. And we do have a right to life because we are human person. This is a very complex and very strong statement in relation to the law. So we should not see them only as a victims of violence, but also as a political agents in transforming the law beyond necropolitics and to end necropolitics. So that's why I use those testimonies, and also those testimonies were only made orally. So I transcribed them, and in order to treat them as a text, since they were not allowed to present a text before the Supreme Court. And I cannot finalize before I mention Thomas, that today there was also a police operation as we are speaking in Rio. Yesterday there was, and today people woke up. We woke up with images of people in São Gonçalo, Rio de Janeiro, literally carrying bodies outside of the community. 8 people so far, but more than that probably were murdered by the police. So 8 people were murdered, at least confirmed, and the community people were actually carrying the bodies out of the community today morning. So is it a democracy? And if not, how we can conceptualize this crisis? So that's my question. Thank you very much for the opportunity to present those ideas.
Thank you so much, Thiago. That was fascinating. I am going to make a few comments. I will try to be brief, but I cannot possibly do justice to the richness of your paper, which is an analysis that cuts across multiple dimensions and relies on a diversity of disciplinary discourses and approaches to unpack what you call the necropolitics of racial democracy, and I'm using that phrase in the non-Brazilian sense, of racist democracy, I perhaps should say, in Brazil. So I want to make very briefly 4 points which echo and engage some of the observations that you have just offered from your paper. And I want to wholeheartedly endorse your inaugural insight in seeking to position the narrative about ADPF 635 and police violence, namely that the crisis of democracy in Brazil is a racial crisis. We have had an explosion in the literature and in the media and in everyday political conversation of this idea that the current moment in the US and Brazil, and indeed in multiple countries around the globe, is a crisis of democracy. Your insight that in the Brazilian context, the nature of the democratic crisis that Brazil faces can only be understood if we reckon with the ways in which it is always also a racial crisis, is absolutely indispensable. And I would say the same about the crisis of democracy in the United States. It is fundamentally a racial crisis which can only be explained through a critical anatomy of the deployment of the discourses of race to legitimize practices of violence which themselves are an exercise of racialized power. Right? And so by bringing race to the center of the conversation about the crisis of democracy, you rightly underline the inseparability in actually existing democracies of a racial lens. Second, in thinking through this question of the mortal life of democracy, how democracies die, and the role of race in that necropolitical process, it's important, I think, to note the continuities across history of racial violence. Because in the same way that the crisis of democracy is a racial crisis, the very constitution of democracy is a racial project. Right? And in their book, How Democracies Die, copy of it here, Stephen Levitsky and Daniel Ziblatt actually note that the democracy in the United States, which they now see to be in mortal danger, and I'm quoting them here, rested to a considerable degree on racial exclusion. So the crisis of democracy is a racial crisis, in part because democracy as we know it has always also been racial democracy, again, in the negative sense, right? Founded in practices that are inescapably implicated in structures of racial power. And Levitsky and Ziblatt actually are speaking euphemistically. They talk about exclusion, but those practices of exclusion were violent, right? And involved political regimes and state practices of black pain and black death. And your paper, I think, powerfully underlines the ways in which we must understand democracy itself and the legitimation practices of democracy through a racial lens. So that brings me to, this observation about democracy is also true of law. Robert Cover, the late Robert Cover, famously wrote that legal interpretation takes place in a field of pain and death. Right? So the law itself is, in some important senses, a structure of violence. What your paper underscores is the specificity of racial violence in law as an interpretive practice and as a political institution. So that frame, I think, helps us understand I think it's not an exaggeration to say, the revolutionary character, right, of the existence of a space in this first case of the Brazilian STF addressing the politics of police violence in Brazil for the voices of the victims of police violence. Right? And the story that you tell is a story of political agency. But it's not just about the voices. Right? It's also, in an important sense, about the bodies of Black Brazilians. It's important in this regard to remember, as Robert Cover reminds us, that the corpus juris of democracy has never relied on legal interpretation alone. Black Brazilians, like their diasporic co-citizens, African Americans, have learned that the life of the law is an embodied flesh and blood experience, which, again, to quote Cover, takes place in a field of pain and death. Right? So from its inception, the political regime that we call American democracy, the political regime that we call Brazilian democracy, has engaged in the literal appropriation of Black bodies as a material surface for projecting its values and power. Right? And one of the ways I think we can understand the presence and the embodied voice of the Afro-Brazilians who spoke in these hearings is by using critical race theory's idea of looking at the bottom, right? Looking to the bottom. Right? as a forensic tool. And we can say that what the witnesses before the STF allowed the court to do, if it was willing to engage in this practice, is to exhume the subjugated knowledge of life at the ethno-racial underbelly of Brazilian politics and of Brazilian political economy. Because I think that the crisis of democracy in Brazil is a crisis of politics, but it's also a crisis of political economy, that is, of capitalism. Right? I think we cannot possibly understand the explosion of police violence that marks the current moment in Brazil apart from the contestation and the conflict that has emerged from the struggle of black Brazilians to be included fully within the political economy of Brazil, right? And so, like the African-American encounter with capitalism from below, the Afro-Brazilian encounter with capitalism from below, and the effort to use the institutions of democracy to address the entrenched structural inequality, right, that has been legislated in the Brazilian system and that characterizes racial governance in Brazil. It's a subaltern source and a site for the creation of legal meanings that, and I'll quote Robert Cover again here, that Cover famously described as juris genesis. Right? So your paper, I think, is focusing on the juris generativity of this testimony and the ways in which it represents what I've called in some of my work an enacted subaltern counter jurisprudence, right? Another knowledge, an existential knowledge of what law and legal capitalism look like from below, right? From its underside, right? And it attempts to address, if not arrest, the symbolic violence of lost complicity, historic complicity in the hermeneutic injustice that has silenced the voice of black people, right? So this is an example of a black juris genesis that I think contests the ways in which the legal system and the political system, like the economic system in Brazil, has depended on the differentiation, the differential evaluation, the stratification, and the hierarchical scaling, to use Iris Marion Young's phrase, of racialized black bodies. Right? And so the creation of a space, of a forum, of a public sphere, right, in which those silenced bodies could give voice to the subjugated knowledge that they have of what the legal system looks like from below at its point of production, right? Which is one way to describe police violence, because police violence is the exercise of legally delegated authority, even when it is wielded in a lawless way, right? That is a crucially important insight, and is part of what you call the process of decolonization in Brazil, and what in the U.S. has been called the process of the politics of abolition, right? The new abolitionism. So what's the takeaway? I think you're right to note the tension between the appeal to law and the ways in which the use of law as a political tool risks the reconsolidation of law's legitimacy at this moment of crisis. And the risk that participation in the institutions of state law, okay, by people who are trying to move from victimhood to political agency, okay, will actually end up shoring up, right, this decadent legal system. But here I would simply say, with Jacques Derrida, Derrida famously noted, talking about human rights, that we need human rights, but human rights are not enough. And what Derrida says of human rights, I would say of law in this context. We need law, right? We need participation in legal institutions, but law is not enough. And so for me, the question is, what are the strategic or tactical engagements with law that anti-racist movements in Brazil and the US can leverage to advance what, at the end of the day, is not just a demand for rights, formally codified rights, and the recognition of those rights by the legal system, but is rather a demand for Black freedom. Right? And if what is at stake here is the future of a Black emancipatory project, and I've been writing a lot about this lately, the move, it seems to me, that those of us who advocate for and are partnering as legal intellectuals with ordinary Black Brazilians and Black Americans have to constantly urge these social movements to make is one which understands the appeal to law, the use of legal institutions, the participation in and the deployment of legal discourse as a political effort to build a culture of critical, democratic, racial literacy, that empowers people to pursue and keep their eyes on the ultimate goal, freedom, and to recognize that the law is one, but not the only, and not always even the most important tool for the social change that these movements seek. So I'll stop there.
Oh, thank you very much, Thomas. Well, I think we do have a question, but I just want to say very briefly that thank you very much for it, because I think you really summarized it and also critically analyzed the paper and brought it interesting insights. And I think that particularly what you mentioned, looking at the law from the bottom and as a forensic tool, as you mentioned, is very interesting. Also, the encounter of capitalism from below, the encounter of violence and law from below. It's a very interesting approach from critical race theory, and kind of it's exactly what I was trying to do by looking at those testimonies and select those testimonies, because also there were other testimonies presented there by NGOs, by human rights organizations, but I decided to select those specifically movements in order to provide strategically this subjugated knowledge, as you mentioned. So I think that, and I liked very much the also another thing that is very interesting from including from the legal perspective, which is this, as you mentioned, the looking at this subjugated knowledge from below at the moment of production of this, and I think that's very interesting, because Just to give a concrete example that was all over the news a few days ago, one Black young activist, he was in a store, and then he left the store a few seconds later because he didn't want to buy anything, and then the police stopped him and said, well, are you stealing something, and accused him, and this was recorded. And the police said something that's very interesting to what you're mentioning about this at the moment of production, because the police said, the young man said, well, what proof do you have that I steal something? And then the police said, well, I have the presumption of truth when I make accusation. So they're like right there, they're employing a legal tool as power. And as you mentioned, of course, this cannot later on, if ever becomes a judicial case, of course, later on it can be contested. But usually when it is contested, the judiciary usually buys and there's literature on that. Usually the judiciary buys the truth that the police is presenting. But this presumption of the lawfulness, or the presumption of even the truthness of the knowledge or the power of the police is interesting. And you mentioned at the moment of production, I think it's very interesting, this tiny example, but I think it's interesting to highlight what you mentioned. And I gave this talk in Princeton and Brown before, and one of the things that usually people in the end ask me is that, well, and I asked them, well, it's not make people depressed or anything like this, but I think that what you mentioned about this emancipatory project is that I want to highlight those testimonies, and I want to highlight these dollars from below as an emancipatory project, in a way to think about another ways that we can conceive not only the law, but also democracy, political economy, in different ways, taking into consideration those knowledges. They are out there. It's just that we usually do not consider them in our analysis, but they exist in real life, and they are somewhere out there. And they are out there in the bodies and also in the voices of those people. So my intent by taking that approach and looking at and listening to those movements and those people is to try to bring this knowledge to the surface of the analysis on democracy, in order to change it, in order to change the democracy, in order to change and try to think radically differently about the law, and also about democracy, and as you mentioned correctly, about political economy. So I think that's kind of we're going to, which is what are the emancipatory projects that we can conceive out of this politics, and I think that's very key and very important.
We have a question from João Rafael da Silva. Hello, Thiago. Thank you for your talk. Recently, as you know, Black women city councilors, congresswomen, have been one of the main victims of political violence, that is terrorism. I think in Brazil, I think. Therefore, how do we change the legal response to necropolitics when our representatives are struggling to fulfill their mandates in the face of death threats and other attacks?
Thank you very much, Juan. I think that's a very key question, because when we and I think it's interesting because you highlighted the political violence, and as we are thinking about the crisis of democracy, or we are thinking about violence itself and the legal responses to them, is that one of the key instruments to maintain racism and this racist democracy is to maintain a level of inequality in terms of political power. That's part of the project. And this can be done by excluding people, basically, from accessing funds from the political parties and not have access to equal opportunities to and real opportunities to be elected. But at the same time, once those are elected, some people are elected, even those people are not protected from violence that is directly at the Black bodies, and especially in relation to political violence. We are seeing Black women's bodies, also transgender people's bodies, are being the main target of those all this violence. So I think that first of all, this happens also because this is part of the project of maintaining inequality in terms of access to political power. Secondly, I think that the way in which the institutions, the legal institutions, respond to those instances are also very representative of the way the legal institutions respond to violence against Black bodies in general, not only political violence. So we look at how the changes and the delay in the investigation, about the changes in the team of the investigation, but also the problem in the investigation for Marielle Franco, for instance, who were killed, city councilwoman who was killed in Rio de Janeiro, in the middle of the city. This was in 2018. And the delay that we do not actually know by the police, by the investigation, who was responsible for ordering the killing and for why. It show, and also the political violence that we are seeing against, as you mentioned, congresswomen and city council women in Brazil. It clearly shows also another instance of how those people are treated by the legal institutions, even if they access some level of a political power, and this political power does not shield them from to protect them from this violence. So how we can think I will do the same as I did with this case of Supreme Court. And there are researchers that did that. For instance, there is a study by the Marielle Franco Institute that was established after her death by her sister, Marielle Franco. And they had a large research on listening and asking political candidates and people who were elected, Black women, how they feel about political violence. At FGV ourselves, we did a research last semester on political violence as well, that is available online. Trying to talk with some candidates and some people that were elected to see how they see the protection from the political violence, and how they see the reaction of legal institutions. And as in the way that we are talking about the violence as the knowledge from below. And I think that it's very powerful to listen to the ways in which they are discriminated, not only by the police or the investigators, but also by their fellow Congress people, and they also by their own political party. But as we are talking about the violence against the people, the communities that live in favelas, I think that here it's part of a larger project of maintaining inequality and maintaining people not having access to political power, and saying that even if they do, they are not fully protected. So, and that's very, so I think that I would employ kind of the same methodology, looking at what they are talking about and how they are seeing the situation in order to change it.
Great. Let's see if there don't seem to be any other questions. We're at 12:57. Gustavo, I'll turn things back over to you. You're muted.
Sorry. Just wanted to, I guess, wrap things up since we're at time. But thank you to all the audience for listening in today. I want to thank Thiago for his wonderful paper. Looking forward to reading it. And Tom, Kendall Thomas, just wonderfully insightful analysis of the paper. And I think it's a really rich study with lots of insights, not just for Brazil, but I think Kendall really drew some interesting parallels with with the U.S. context and really kind of the underscoring this critical piece of your work, which is this kind of connecting this with the sort of a broader crisis of democracy in both of our countries. So thank you for being here. And just as a final note, I also wanted to thank the Brazil Talk student group, who are co-sponsors of this event. We really appreciate their support in helping to get the word out and making this event a success. And so thank you very much. And, you know, if anybody wants to look into other things that are going on through the Brazil Center at the Institute of Latin American Studies, you can visit our website and check out our events calendar. We have another event coming up later in December with Kendall again, talking again about the Supreme Court in Brazil.
Thank you.
Muito obrigado.
Muito obrigado.